the Khumalo's arrest is a project.
That document you're holding in your hand, IDEC solicited it from Mr. Adams. You received a letter from the minister. You then directed Mr. Perumal to act on that and contact Mr. Adams and
ask him for his...
Ask him. So you solicited a Section 27 affidavit from a would-be complainant.
I don't agree with the solicited.
Ma'am?
I don't agree with solicited. We would have asked him. Because, you see, I'm going into the detail that's not mine and not in my head, and I don't want to sound
yours. It's yours. It's yours, Advocate Johnson. You are the one who gave an instruction to Chief Perumal to contact Mr. Adams. So Ms. Sillo's question relates to that. That has nothing to do. Mr. Perumal would then have been the actor on your instruction. That's where the question is. It has nothing to do with what Mr. Perumal then did down the line. So please do not deflect the question and refer to what Mr. Perumal would have done or not done. Can you please respond to the question?
Then we would have obtained the statement.
At your instance, that's the substance of the question.
That is correct.
That's what Ms. Sillo means when she says to you, so you solicited the affidavit, because what came out of your instruction that please contact Mr. Adams was the submission of the Section 27 affidavit. So it's on that basis that Ms. Sillo is suggesting to you, you solicited that affidavit. Do you now agree?
I agree.
As you sit here today, is that appropriate of IDEC to be soliciting complaints from members of the public on the basis of which then IDEC initiates investigations?
No, we're not supposed to solicit. And that is why I'm saying I tell Mr. Perumal to engage Mr. Adams. I don't know if this was a prepared affidavit already.
Can you please respond to Commissioner Baloy's question?
Commissioner Chair, I'm trying to make logic of it. As a layman, please excuse me on that. I'm a policeman, I'm an investigator. An allegation is made. We have the Section 71A, we have, apologies, I have to go there. It is authorized, the investigation, and I cannot speak from management what they utilized to authorize this investigation, but it is down on my level, that has come down on my level with regards to this allegation. So when I look at this affidavit and I read at this allegation, and in terms of my preliminary investigation, there's a serious allegation here that is made where processes, we use the word manipulated or whatever. So I start my investigation from there. I'm not looking for any word of civilian or anything else. I'm talking about basic as I'm trying to explain myself as a layman, and I cannot take it any further except what I say here. A person was appointed, processes were manipulated, the person had no experience. That is my start to go out there and look at it and confirm it with further investigation. Chair, Commissioner, I can take it no further than what I've said there.
In how you've described it, just how you've captured it now,
Chair,
that seems a typical HR matter that the Public Service Commission would deal with. If you had taken this affidavit to the PSC, and I'm saying just from how you've captured it, that it seems something that falls squarely within the powers of the Public Service Commission. And you took exception yesterday quite strongly to General Mkwanazi saying you lack the experience to investigate matters. Yeah, rightly so, because you've taken us through your qualifications. But as an experienced investigator, even acting on your superior's decision, Ms. Johnson, maybe Perumal and whoever the committee is, them having made a decision that this is a matter to be investigated, I would expect that you, as an experienced investigator that you are, you would have looked at this affidavit and said, but this is an HR matter.
Either you read this A1, which is the first statement in your docket. Either you read it in the context of another document, which could, the only one I can think of is the Section 27 affidavit. But as you correctly point out, you testified that you said you've never had sight of it. You only had sight of it recently. I've got no basis to gainsay that. So I accept what you say. You didn't see the Section 27. But I want to know the document that precedes this one, this statement, that you took into consideration to understand that the issues are bigger than just employing that civilian. Which document is that? Sorry, if I may finish, I do apologize. I know I'm aware of the various other statements in the docket, but they all succeed this document. They come after this document. So they are not relevant for purposes of my question. The only other document you'd have taken into consideration is one that either came into existence at the same time as that one or preceded this one that we have. What document is that?
Thank you, Chair, Commissioners. Here's my response, in which I've said before, that there's no other document, and I said the Section 27, I had no insight into it.
And what the definition contemplates. It contemplates that in return she must do something illegal, something improper, something unlawful.
Yes, sir. That's what I'm saying, is that what she was going to do is not going to be done immediately, but what you're supposed to give back was not going to be immediately, but can be given at a later stage because of the position that she was appointed in.
She was going to do something illegal.
Correct.
Some years later.
No, we do not know when that would be. But
Precisely the problem.
Because you don't know, that's precisely the problem.
That's precisely the problem with this. That you have you formulated a charge, you got a warrant of arrest, you got people arrested, you have people appearing in court, and continue to do so on the basis of something that you say, and rightly so, fairly so. You say, well, we don't know, maybe in future she was going to do that. How does that, for a seasoned investigator, how does that sound right? As you say it, we don't know, maybe in future she was going to do that, and you've taken all these drastic steps that have a consequence on people's lives and have had a consequence. And you sit there now, many months later, you say, well, we don't know. Maybe she was going to do it in future. It cannot be right that that's a basis on which you went and instituted this prosecution and got a warrant of arrest. That's precisely the problem with this.
Yes.
Their normal role.
Yes, investigators executing a warrant of arrest.
Okay.
Thank you. I think from yesterday.
Sorry. Before you go on,
sure.
before I just, you'll remember yesterday when I even expressed myself in Africa, saying that. Klaar, dear Mekar. When you responded to me about whether or on whether Colonel Padiache had ever had sight of or received the Section 27 referral affidavit, my distinct impression was that you said, yes, he did. But when immediately thereafter Commissioner Baloyi engaged you, my sense was then that you were saying the opposite. I'm not sure as I sit here what your final position is on that. I just want us to put that to bed. Did he or did he not receive that Section 27 referral affidavit?
Chair, as I undertook that I would get clarity
Yes.
from the team, he did have sight of the Section 27.
He was given, in the sense of being given.
He had sight of it. That's the answer I have.
You see,
So-
you may have sight, in
But-
the same way as, for example, police officers will flash their ID cards just like that. Or you may have sight in the sense that you are given the document, you read it, you internalize its contents. So was he given that document for him to personally read and internalize its contents?
So initially he would have had sight of it, and later in the year, when he had all the dockets.
No, explain having sight. That's what I'm interested in. What do you mean by that?
That when the team met, they engaged the 27, and he is part of that team.
No. That doesn't answer me. What do you mean when you say he had sight of it? Surely you understand the essence.
He saw the document.
Seeing as in, here's a document, it's lifted, and he does see it if it's lifted like this. But if it's immediately put back on the table, it's as good as not having been seen by him. So what do you mean by he did have sight of it?
So I'm giving you I'm giving you an explanation I get because I'm not inside of that group.
That's far you have not explained. That's why I want, what do you mean when you say he had sight of it? You have not explained it.
He saw the document.
I want to understand seeing. Is it in the sense of it being flashed? Here's a Section 27 referral affidavit, boom, it's gone back to the top of the table and he doesn't see anything. Is that what you mean by seeing? Or do you mean it was given to him for him to peruse it for himself?
He was given the document to peruse for himself, according to him and to the team, much later
That's
on.
all I wanted.
Much later on.
Sorry, much later?
Much later on.
At what stage was that? At what stage was that? Was this before he started investigating, or was it after he had commenced investigating? If it's the latter, that would mean his investigation was not informed by the affidavit. So you say after he had commenced?
After he had commenced.
Investigating.
That is
so
correct.
After the Section 28 investigation had commenced?
Yes.
All right. Thank you. Now that answers me. And the Claude Diermekar is gone.
And apologies, but it is answers I had to seek because
Yes.
it's not my direct knowledge.
Yes,
So if I
yes.
didn't convey it correctly, I do apologize, but it's the answer that I was given.
No. As I said yesterday, hearsay evidence is admissible in this commission. There's authority that says a commission of inquiry of this nature may inform itself in whatever manner it wishes to. The only issue, depending on the nature of the evidence, would be the probative value of such evidence. Thank you.
Thank you.
Did they say exactly when? Because in your response to the chair, you said later in the year. Now that worries me because the arrests were mid-year. So if later in the year is after the arrests, that is a problem. So when you say later in the year, what do you mean? Do you mean after June or before June 2025?
It would have had to have been before June 2025 because he became the investigator earlier on, which was
In January?
in January.
Yes.
Yes.
Yeah, I don't think it's an answer that that kind of question where you answer it would have been. You have had opportunity to ask, and you were told you saw it later on. You either did ask and were informed when later on, or you must still go back and find out when exactly did he see it, because the way you're answering, you don't have personal knowledge of it, so you have to check with other people, and we shouldn't be left with the impression that yes, he saw it before the arrest because of how you've answered. I think it's a question that you must verify and come back to us with a specific period.
I will do that, Commissioner Baloyi, with the exact answer.
Finally, do you dispute his version when he says before this commission that he did not see the Section 27 affidavit? Do you dispute his version? Do you say he's not telling the truth?
I'm unable to dispute his version because he's in that team. That is why I'm saying I have to ask the questions after the fact.
Thank you.
It's not my place to say he lied. He would have to, he explained as he did, yes.
Thank you. And thank you, Advocate Johnson.
You're still going to be discussing the Section 27 notice. I do have a question, but if it's a topic, you are still going
Section
to cover.
27 affidavit.
Affidavit.
Yes.
Okay.
We're still
Thanks.
going to.
All right, I'll leave my question for now.
Thanks, Commissioner. You gave this long, it's quite a big team. You informed of, I think, Ayanda Mbalo, Charles Els. From yesterday, you keep referencing Chief Perumal. Chief is not his name, is it?
No, it is the rank. He is Dylan Perumal.
Dylan, thank you. Now, you now have, as I understand, a group of prosecutors. Well, the prosecutors, there are two, and then a group of investigators. Who leads then this entire team? Who's the leader of this particular team?
It is the Deputy Director of Public Prosecutions who leads the team. And then within the team, you will have, as you have a chief investigator who will lead the investigative part of the investigations. But the team is led by the Deputy Director of Public Prosecutions.
Okay, and in this case, that would be Mr. Manilau.
That is correct.
That is the leader of this team.
Yes.
Not Chief Perumal.
No.
Because I understood Colonel Padiache to refer to Chief Perumal as the leader of the team. Was he perhaps wrong in your understanding?
Not wrong. I think as an investigator, having the chief criminal investigator in the team, they look to him as the leader of the investigations. They almost
particulars. No particulars have been provided as to who made the allegation, which docket is implicated, when or where the alleged disclosures took place, how the docket was allegedly disclosed, and so on. Say this is a serious allegation against you. Now, as at the date of this statement, you could not respond particularly to the allegation that you had disclosed the docket to him. The subpoena speaks of a docket. Your answer seems to suggest that you are not able to respond to paragraph 2.6 because you haven't been given the details of the docket, which would suggest that you are not in a position to do so because there may very well be more than one docket. Is that where we land?
No.
Okay.
For me, your relationship and allegations that you disclosed to General Khan, a SEPS docket relating to an ongoing criminal investigation, I was seeking the details of this docket and who made the allegation, because on the 10th, I didn't have that.
My apologies. Sorry. Against General Khan himself.
Yes.
That is the important rider. So the allegation is about you disclosing a docket to General Khan regarding an investigation into General Khan's conduct. That's how precise it is. So your answer, when you say no particulars have been provided, I'm not clear what particulars, you say which docket is implicated, then it leaves with me the impression that there may be more than one docket implicated. You just want clarity as to which docket is implicated, where you disclosed to General Khan a docket relating to ongoing investigations against him. I'm struggling with your response at 20, and I would like you to clarify perhaps. Because the subpoena seems to suggest one docket.
Yes.
Your answer seems to suggest I can't pinpoint the docket because you don't give me the details of which docket is implicated, implying there may potentially be more than one.
On a point of correction,
Yes.
there isn't more than one.
Okay.
And it became, and at the time, I didn't recall disclosing a docket.
Yes.
When the evidence is then presented and witnesses testify, I'm replying to this affidavit on the 10th. And then people are testifying on the 10th. And it is only then I realize what is being referred to. And hence the third affidavit that was then made. Because I now have more details about the docket that is being alleged to have been disclosed.
So the effect, some effect of that is, had the witness not testified, you would still have not responded to the allegation that you handed a docket over. You wouldn't recall. I'm trying to understand, how does the testimony of the witnesses who appeared here on that Friday trigger your memory regarding a disclosure of a docket? You either know you did or you have never in your entire life. Where exactly were you on the 10th when you prepared the statement?
We were in consultations with
Yeah,
yourself.
in
Yes.
your mind, in your headspace. Sorry, I meant. Had you ever disclosed a docket such as described at 2.6 or never at all?
That is why I needed my memory to be jogged.
Okay.
And then it'll take us into those aspects that we want to touch on in 3. And not because I don't want to...
In statement 3.
Statement 3.
Statement
Yes, statement
3.
Okay. Well, I think you have taken us up to your paragraph, the requirements of Section 27, and what would be the consequences of non-compliance.
So given the questions that were posed by the chair, it was, I had not looked at it.
And not only the questions and the responses.
Yes. So on the basis thereof, commissioners, I've applied my mind differently. The commission has pointed something out quite differently that ought to have been considered. I'm saying in the manner in which I applied my mind at the time, based on how I understood Section B, or what Section B to mean, at the time, yes. I agreed that it fulfilled that requirement because he had knowledge. He had grounds on which it was based. I've given the answer, Commissioner. I can't change that answer.
Are you seriously telling us that since what you've been the director since 2022, is it?
Yes.
Are you telling us that since 2022, this is how you've understood your legal mandate, or
No.
IDEX legal mandate?
No.
Did I understand you correctly to suggest that you understood that the suspicion required has to be viewed subjectively? Did I understand you to say that? I'm asking you this because you said you believe that he had the required suspicion. He, Mr. Adams.
Yes.
Did I understand you correctly?
Correct.
So that's subjective as opposed to objective. So did you understand the test to be a subjective test as opposed to an objective test?
For me, the grounds on which the suspicion is based is a subjective test.
I will.
No, I'm not going back on the argument.
Okay,
I'm saying
okay,
in the way I've applied my mind, this is a reasonable suspicion
Yes.
that must be borne by a reasonable man and a person, by a reasonable person who must have access to knowledge and or information that brings them to that point. If you would allow me to just take it just a moment further.
Yes.
Mr. Adams is a member of the Police Portfolio Committee. These allegations come to them from time to time. There's active engagement with the police. there are documents that are shared, there's information that is shared. I did not take his to be just the test of a subjective mind of just a reasonable man.
No. You can't obfuscate issues in the manner in which you are saying. You said you considered the test to be subjective. Now you are saying something that suggests that somehow you also considered it to be objective. You cannot have it both ways. Please, Advocate Johnson. Let me ask you the question again. Did you consider the test to be subjective?
Correct.
Now, what are you saying? You've just said something that seems to suggest that you also considered it to be objective. Make me understand what you are saying.
Maybe I didn't express myself correctly. I'm saying that the reasonable man test, the person test, applies. But
once you see, therein lies the problem. Once you say that the test is subjective, then you look to what was going on in a specific person's mind. That's subjective. It has nothing to do with a reasonable person. That's subjective. You cannot have it both ways. Law 101 says subjective, you look to the person's mind. Objective, you test that in accordance with how a reasonable person would view the situation. The two are totally different. You cannot want to compound them. You simply cannot. You cannot say it's subjective, but then also refer to a reasonable person test. You cannot. I mean, even a law student doing first year would know that at a later stage during their first year of legal studies. In fact, across the board within legal studies, you go to your law of delict, you go to even criminal law, your culpable homicide, you encounter the reasonable test across the board. So how you could mix the subjective test and the objective test completely escapes me. So back to my question, you have said you accept, or rather you say the test under Section 27 is a subjective test. Do you stand by that? Because if you do, it raises very serious issues about your application of the section
yes.
Over all these years. Are you sticking to your assertion that the test is subjective, even though it uses reasonable? Once you have reasonable, that leads to the objective test. You should know that. Yes. Are you insisting that the test is subjective?
It is an objective test of the reasonable person.
It's an objective test.
Yes.
Yeah, you don't even need to go to reasonable person. Reasonable person is implied in the concept of an objective test. So you don't even need to go there. Now, if it is objective, did you operate, when you looked at this referral, did you operate on the basis that here I'm concerned with the objective test? Is that how you applied it? Because my sense when you responded to Ms. Sillo was that you thought it's subjective. And indeed, even here, until my 2 or so questions before now, you were saying it's subjective. It's subjective. So that must clearly mean that you looked at this referral affidavit on the basis that the test was subjective. Is that so? Is that so?
I looked at the Section 27 on the test of the
subjective, it must be.
At the time, yes.
It must be, because that's what you believed. Hence your answers on a few good times now during this engagement, your answers that the test is subjective. So you looked at this on the basis that it is subjective. You agree again?
Yes.
So that means in your case, the word reasonable, which appears in so many words in Section 27, did not come into the equation whatsoever. Is that so?
It does, Because
No,
of
it
the
couldn't.
first
Not if the test is subjective according to you. It wouldn't. Because once you talk reasonable, that takes you to the objective test. And you have said, in your mind, that did not apply. So you looked at this on the basis that it was the subjective test that applied, correct?
Correct?
So reasonable did not come into the equation to your mind, correct?
The reasonable that comes to mind is as per any person has reasonable grounds to suspect. It dealt with
But-
the offences, which was part A.
It's there fine and you are reading it fine. But what I'm saying is, if you believe that the test is subjective, then reasonable, on your understanding, does not come into the equation. Because once you bring into the equation the word reasonable, that's already taking you to the objective test. You have said, on your understanding, the test was subjective. Therefore, reasonable would not have come into your equation, not on your approach. You must accept that.
I hear you, Commissioner.
Do you accept it?
I accept that.
Thank you.
Thank you, Chair. Based on the engagement you just had with the Chair, would it be a fair understanding that all your approaches to all Section 27 referrals you've had is the attitude you had to this particular one? So IDEC initiated investigations based on numerous of such affidavits which don't advance any grounds to support suspicions expressed therein. Has that been the case throughout the years you've been at IDEC?
No, ma'am.
And why then how have the other affidavits been dealt with? Have you interrogated their compliance with Section 27 before initiating an investigation?
Yes, the other affidavits were quite different. You'd also see, I think you requested from us the affidavit of a different witness. Yeah. When you read those as well, you can see the compliance with these sections.
Why didn't you bring to bear that particular need for compliance to this particular affidavit, which is dated less than 2 years ago, November 24? Why did you treat this affidavit as an exception to the rule that you say you had come to apply to all other Section 27 affidavits?
So I'm not going back.
Yes.
And I think that is where my fault line lay, is understanding what the reasonable person, and went back into subjective. That was my error. It is an error. It was an honest error. The test isn't subjective, the test is objective. Here I brought a subjective mind to bear on the information the person gave us.
And Advocate Johnson, that is apparent from paragraph 4, because Mr. Adams says none of these people were suitable to be appointed to the post. That's his personal view, without
Correct.
grounds to support that.
Correct.
He doesn't even say they did not meet the minimum criteria, they did not have the qualifications. He just says, you appointed somebody from BMW as a brigadier, and then he says, not suitable, full stop. Why are they not suitable? Do they not meet the qualifications? He does not even identify the offense that he suspects is being committed there. Because appointment of somebody from BMW on its own does not tell you anything. Because my immediate question would be, what is wrong with appointing somebody, an engineer from BMW? If the position required an engineer, what would be wrong with that?
Correct.
That would be my immediate question. And I would need that to be addressed in the affidavit itself. Because the entry point, according to Section 27, is that the affidavit must specify 1, 2, 3. Not that it must set out the suspicion and then the grounds IDEC will figure them out for itself.
Understood.
Just on an answer you gave in response to Ms. Sillo, You said an error that you committed was not to apply was to apply the subjective test. The test is in fact objective. In that response, based on the answers you gave to me, and repeating the same thing a good few times throughout until your engagement with me, the distinct impression I got was that you've always understood the test to be subjective. Correct?
I understood the test to be the reasonable person test, which is an objective test.
Okay, I will not go back. I engaged you on the subjective and so on because you cannot marry subjective and objective. It simply can. Let me ask you this question. So throughout, your understanding of Section 27 was in accordance with the responses you gave when I engaged you. As to what those were, the transcript will assist us. Throughout, that was your understanding. It is only now that you have clarity as to what exactly the test is. That is a test which is not subjective as you suggested it was, or a test which does not seek to mix a subjective and objective test. It is simply objective. So before now, you had, I feel bad to have to use this word, but your understanding was this muddled view of what the test was, which muddled view came out as I engaged you. So that was your understanding until now, until during this engagement. Is that a fair suggestion to you?
It is fair.
Thank you.
Can I just say, Ms. Johnson, that even allowing for it was an error, you applied the subjective test because of your misunderstanding of the test that applies. Even on that, in this affidavit, insofar as 27B requires him to set out grounds, this affidavit doesn't set out any grounds. To say I received an envelope that has procurement matters, that's not a ground. It doesn't tell you anything about the contents of the envelope. For all I care, those procurement documents may well not demonstrate anything wrong. So it's not clear to me when you say, well, I accepted because he's a member of parliament who serves in the portfolio committee, that when he says he has an envelope that is sufficient, you surely must know and understand that for you to say this falls within our mandate, you need to satisfy yourself with whatever it is he's relying on. So I don't accept that what you say is an error on your part of applying the wrong test, that it explains what happened here. It doesn't. Even on that error, I would expect you, as you understand the section, it says he must set out grounds, and he doesn't. He doesn't. When he goes on to say 4 other colonels who qualified or were employed in crime intelligence, none of them were suitable to be appointed in this post, it doesn't tell you anything about this candidate that was appointed. It doesn't. So it is clear in 27B that he does